All right, so it's 1 o'clock. We will get started. I anticipate a lot more individuals joining because we had over 80 registrants and we have about 20 that's online now. But I do want us to honor the time of everyone that is here. I'd like to welcome you to our 6th webinar in our Corona Collaboration Culture Series, specifically entitled Legal Considerations Amidst COVID-19. I am excited about this session. Let me tell you why. As a result of COVID-19, there have been a lot of changes that organizations and individuals have had to make. And I am a major proponent of the fact that knowledge is power. And I think that we need to understand what the extent of those changes are and understand what our responsibilities are as employees and citizens, and also what employers are responsible to us for. And we'll get into that today. So my name is Wellington Hepburn. I'm the president of Wellington Hepburn International, which is a local and international company focused on motivational speaking, keynotes, workshops, trainings, and we're also getting into book authoring. I'd like to welcome all of you that have taken time out of your Sunday to be here. I'd like to welcome our Bahamian participants. Thank you for joining. And I'd also like to welcome our international participants. Over the previous 5 sessions, we've had participants from Spain, Malaysia, Canada, the UK, and also Africa. So I really want to say thank you for taking time out to participate today. A couple of things I want to highlight before I hand it over to Kishel and hand it over to Darren. So a few meeting guidelines. I would encourage you to please keep your mics on mute as we have Darren doing his presentation. We do have a structured, as in all the other previous sessions, a structured Q&A session where you can take your mic off mute, or if you wish, you can drop a question into the chat so that we can get your questions answered. Since this topic, I'll steal a line from Darrell Miller, is going to be very lively and provocative. What we've done is we've doubled our Q&A time. So instead of having 20 minutes of Q&A, we're dedicating 40 minutes to question and answers just for you as participants so that you could learn, grow faster, further, longer, stronger. So bear that in mind. And I also want to just touch on this concept of Zoom bombing. In the past, there have been some webinars that have been hacked and individuals have done less than savory things. We don't anticipate that happening on this webinar, but if something like that happens, know that I will end the webinar immediately. As a part of your registration process, I would have gotten your email addresses. And you can expect a communication from me within 5 minutes to determine how we will continue the webinar, most likely with another link. All right. So in terms of the format today, we're going to have some basic introductions. Then we will have a 30-minute presentation by Darren Bain. And then after that, like I said, we'll have 40 minutes of Q&A where we get to hear from each one of you and make sure all of your questions and concerns are answered. All right, so over to you, Kishel.
All right, so good afternoon, everyone. I acknowledge all of you for being here and really and truly want to just briefly speak about the collaboration between Wellington Hepburn International and the Training Authority. First of all, the Training Authority, our mission is to help teams perform, people to excel and businesses to grow, and that's what we do through workshops, programs, events. And Wellington and I share the same mission. Yeah. And goal really is to educate, empower, inspire people to succeed and excel in whatever endeavor that they have. And so this is a continuation of, I think this is the third session that we've done together, Wellington. And I trust that the information has been valuable to you so far that you can take and apply to your respective lives.
Absolutely, absolutely. So let me tell you very quickly, well, no, actually, Darren, you introduce yourself. Look at me, I'm so excited for this session, Darren. Right. I'm getting ahead of myself.
Right, right. Well, first of all, good afternoon to everyone. It's certainly a delight for me to be here with you today. I trust that we are able to have a good discussion today, where we're able to share some information with you all that I hope will be beneficial to you. I'm the principal of Lignum Advisors. Lignum Advisors is a boutique law firm where we specialize in civil and commercial litigation. I'm also I'm a little fella from Yellow Elder, so I have to stay grounded to that. And my grandmother was from Little Creek, South Andros, so I commonly refer to myself as Neighboy. So if you want to, in your address today, if you call me Neighboy, I have no difficulty with that. But it's really a joy to be here today to be able to share with you.
Absolutely. Thank you, Darren. And we'll hear more from Darren in a few minutes. So very briefly about the Corona Collaboration Series. So the Corona Collaboration Culture Series is a 13-part webinar series that WHI has come up with. And the whole intent behind this series is to just help individuals learn and grow and become better. We've done previous sessions on, working from home. How do you do that successfully? What's the difference between being on lockdown and not feeling like you are locked up? Because that's two different things. 2 weeks ago, we did a session on data-driven decisions, where we heard from Dr. Danny Davis, who actually maintains the analytical framework behind COVID-19 and all of the dashboarding, forecasting, and reporting that you see being put out by the government. So the whole intent behind the C3 series is to help us become better in this time. If you've not noticed yet, pay keen attention and notice that the world has shifted. The entire world has shifted in the way that governments operate, companies operate. I'm sure you feel it in your family and even individually. And the only way we can be effective during this shift, this transition, is through knowledge and making sure that we have the requisite knowledge that we have to be effective. So the C3 series is focused on creating opportunities to share that knowledge. We have some upcoming sessions that talk about how do you promote your health even while you're home. We have a session, next week's session, that talks about how even though we're being encouraged to socially distance, we should not be socially separated, because the two are not the same. In crises, if anything, we should come together as a society. So stay tuned to the C3 series. We're trying to push some boundaries. We're doing some new and different, as we always try to do at WHI. And the intent is to help you learn and grow. We're also selling some digital workbooks as a part of each webinar. So if you're interested in that, speak to me offline, send me an email, drop me a WhatsApp. And we're also providing digital participant certificates. So if you'd like to have a keepsake that shows your participation in this series for each webinar, you can speak to me offline about that also. All right. So now let's get into the meat of today's presentation. So we'll hand it over to Darren Bain. He has a presentation that he's going to take us through for the next 30 minutes. That speaks, well, he'll tell you what's covered in the presentation. I'll leave that up to him. But I do want you to, as he presents, to keep record of your questions. We are going to take all questions at the end of his presentation. Like I would have said, we've dedicated 40 minutes, so we should be able to get through all of your presentations effectively. All right, so drop your questions in the chat, scribble them down, make a note, and after Darren's done, then we'll take your questions. All right, so Darren, over to you.
Okay. All right, again, good afternoon to everyone. And again, I trust that all of you are well. It's really a joy of mine to be able to share with you today, and I want to commend Wellington and his group, and of course, Keishel as well, in the partnership they have put together to be able to bring this information to you. As I said in the beginning, I trust that the information we share today will through this pandemic that we don't have any answers for, and we pray that you will be able to enjoy it. Let's just have a quick word of prayer. Father, we thank you for this day. We pray that you have the words that we share with this listening audience to be able to bring honor and glory to your name. We pray that the information we share will be timely and beneficial, and that you will be glorified at the end of the day. In all things we say thank you. Amen.
Amen.
My presentation today, I'm just going to I'm going to share my screen with you so that you'll be able to see the points that we're seeking to discuss today. And then after I share the presentation, I will come back in. So for the most part, for the presentation, you won't physically see me on screen. I'll be sharing my screen with you.
So Darren, sorry to interrupt you. One participant is saying, can you speak a little louder? Just so, okay. Yeah, or maybe turn your mic volume up.
Sure. Is that better?
Yes, that's better.
Okay, good.
That's better.
Okay, we all set?
Yes.
Good. Just a little proverb to start off our presentation. And as we go through this pandemic, COVID-19, I want to share this quote which I think may be able to assist us in trying to get through it. Just when the caterpillar thought the world was over, it became a butterfly. And I think that is so true for all of us right now as we're going through COVID-19. Sometimes it appears to be dark. But I think as we start to look at it now, there is some light at the end of the tunnel. And so I'm hoping that the level of despair that may have set it has now begun to dissipate, and we're now seeing the light at the end of the tunnel, and we're going to be able to get through this together. The points that I'm going to discuss, particularly in this conversation today, as a matter of legal consideration, are really employment concerns. And then, of course, having a review of some summary issues surrounding simple contracts. And so those are the two main points of which our presentation will focus on today. In the context of employment concerns, no doubt perhaps the first concern is the issue of layoffs or short-term work, and what does that mean? And then as we go through, I won't say come out, but as we go through COVID-19, many of you have gone back to work. Some of you may not have gone back to work as yet, but undoubtedly for whether you are at work now or whether you're going back, you'll recognize that there is indeed a new workplace. And so it's important for us to examine what the obligations of the employer may be, what the obligation of the employees are in this new workplace. And so we're going to look at what the legal issues are surrounding that new workplace. Let's get right into the first issue, that is layoffs or short-term layoffs. And as I address you today, I'm really focusing on the Employment Amendment Act 2017. And so throughout my discussion today, if you hear me use the word the act, I'm referring to the Employment Act of 2017. There is, of course, the Employment Act, which is the substantive body that governs the relationship. And so I may use the word the Employment Act, that's when I'm referring to the Employment Act. Or if I say the act, I'm referring now to the Employment Amendment Act of 2017. The act is particularly important because this would have been the piece of legislation that, if not all, a great majority of employers would have been taking consultation from their attorneys from, sometime perhaps or about March 15th, 16th, or even before, when we now had the imposition of the government shutdown. And there was the concern by employers as to the uncertainty in terms of we don't know when we will be returning to work. And so in those instances, the question was, what do we do? Is there a piece of legislation, is there any law that assists us in understanding what we can do during this interim period? And so what the Act has provided and provides that, yes, you can have a short term or you can have a layoff, which will go to a maximum of 12 weeks. And I want you to keep that number in your head in terms of 12 weeks and what that means as we go through the presentation. But it's not something that you could find that can be done just arbitrarily. There is a process that the Act mandates that the employer must engage in to make certain that the process of the layoffs is correct. And the Act sets it out very clearly, and it says that where there are more than 20 employees to be affected by this layoff, there ought to be this consultation, and the consultation must be 2 weeks prior to the contemplated layoff. And so it tells you that there must be consultation. It tells us again that where there are less than 20 employees, then the consultation must be 1 week prior to the contemplated layoff. Now, that would have been sometime about March. Now we're going into the end of May, going into June. This act, in terms of its relevance, does not stop because you may find it's now some businesses are being reopened. It's a relevant act because there may come the period of time again, even when business starts to resume, that some businesses may not come back online as they were prior to COVID-19. And so therefore, there may yet still be the concern, or there may still be the consideration by the employer that I have to lay some people off. And even if that thought is a consideration by the employer, the Act is the process that you must employ, and it tells you where there are 20 or more employees 2 weeks prior to the contemplated layoff, or less than 20 employees, then you have a 1 week period in terms of the actual notice period for the consultation.
Yes.
And so that is the first consideration in terms of the 2 weeks or 1 week, 20 or less. There's also the requirement that you have to supply the recognized trade union, if there is one, and or the minister with a written statement of what the actual reasoning for the layoffs that you're contemplating as an employer. And here's what the Act says. It says, in terms of the consultation, the patient shall, 1, outline the proposed method of selection. And I would make the submission to you that as we go through this presentation, the mischief behind the Act was to make certain that if there are going to be layoffs, there is not just some random selection of employee A or employee B, but that the employer gives a fair consideration to what their workforce consists of, and then make a fair determination as to what method that they're going to employ in respect to what the layoffs are going to be. Now, what you would have found is that really and truly in the Bahamas, and some may argue the world over, because of the COVID-19 pandemic, there was a wholesale layoff of employees. And so therefore, there was not this sort of selection as to who it was. There was just everybody laid off because there was no work at the time. This particular provision may become even more relevant now as some companies start to reopen, but they're not reopening to the level that they were prior to COVID-19. And there is the contemplation of layoff. And so therefore, they have now got to outline what that method of selection is in regards to the layoff. Then they also have to advise in the consultation the proposed method of layoffs with regard to any agreed procedure. And so let's say, for example, if the employee handbook, or let's say maybe some agreement exists in the organization that speaks to the way employees are laid off, then you've got to outline as an employer that you've given consideration to what that agreed procedure is. And then thirdly, the consultation must outline whether there is any opportunity to find alternative employment for the employees. And so there may be a situation, for example, where an individual is employed as a bartender, but because of what is happening, because the employer is now not coming back on stream, maybe with, they would have had 5 bars, it's now got 2 bars, but they've now got an opening, perhaps, let's say, in public space or space cleaning or something of that sort. So the question now is, they say to the employee, I don't have any space here in regards to you being a bartender. However, there is the opportunity for alternative employment where you now employ in public areas, space clinic, etc. So they're saying to the employee, I'm now making available to you alternative employment within the organization, and that consultation must go ahead and have regard to what those alternative employment opportunities are. Now, so that's the process in terms of consultation. Now we have the question in terms of what are really the reasons why the employer can lay someone off. And the Employment Act specifically tells us that where the employer has temporarily ceased or intends to cease to carry on the business, or from the place where the employee was employed. And so, again, having regard to the pandemic of COVID-19, a lot of employers, businesses will cease their operation, quite frankly, just will not return. And so therefore, in that regard, let's say about March there was layoffs because the business had temporarily ceased. We're now perhaps for some people going into now May, June, where there may be the resurgence or there may be persons coming back into work. And so therefore, those given the reasons why the employer can engage in a layoff where they temporarily cease, or let's say the requirements of the business for the employee to carry out that particular work. Let's pause there a moment. Again, I gave the illustration. Let's say, for example, you now have a situation where there is a restaurant and they would have had wait staff and they would have had staff as bartenders, etc. However, because you now have a situation whereas we're now just doing, at this particular point, only doing curbside service. So for this particular reason, we don't have that particular job function. That is to say, there's no need for a bartender. So the act itself makes a provision that there can be layoff, but I want you to keep that word layoff at the back of your mind because I'm going to come back to that when we start to consider the issue of redundancy. But if that particular function is no longer available, then the act says that you have the ability to lay off that employee, but to a maximum of 12 weeks. So these are the requirements that it sets out. A lot of employees, and I've seen the question to say, okay, fine, I've been employed with company A for the past 15 years. COVID-19 has come in. They have laid me off on about the 15th of March. What does that mean in respect to my continuity or my continuous employment? And the answer is this. The Act specifically says that this layoff does not interrupt your continuous employment. So it cannot be the position by the employer that when I laid you off on the 15th of March, 16th of March, whenever the period was, and if I were to bring you back now on the 15th of June, you're starting over anew. No, the Employment Act says very specifically that the layoff does not interrupt the employment. That's very important to know. So those are the considerations we have. And we said that that period of time that the Employment Act says is 12 weeks. Now, the reason I keep saying 12 weeks is that some of you may have heard the utterances from the Director of Labor, where there may be some sort of advocacy or some sort of lobbying to the government to say, you know, in truth, the 12-week period is not sufficient time because we recognize that a great number of businesses will not be up and running on or about, let's say, for example, the 15th of June. And so there may be the urge, I suppose, of the lobbying where they're asking for that 12-week period to be extended. And so that is the consideration that is, I suppose, I don't know for a fact, that may be given by the government to say whether or not they are prepared for the period of time. But for the present purpose of this conversation, we have to take the law as it is at the moment. And at the moment it is 12 weeks. And so therefore there's some very particular dates that employees and employees are concerned about. To my mind, those dates are the 1st, 8th, and 15th of June. And I'm going to come to why those dates are so important. And so having regard to those dates, the question really is, will employees be made redundant? Is really the question. And the second point is, will their employment continue? And so these are the pragmatic questions that are in the minds of a great number of employees and employers having regard to what the Act has provided for. So we have the consideration now, where let's say, for example, persons have been off from the 15th of March, and we know we got the 15th of March, 15th of April, 15th, and so therefore, when we get to that 12-week period, the question now is this: what do we do? Because the Employment Act tells us that the employer can make an employee redundant where the employer has ceased or intends to cease to carry on the business, or the particular kind of work has ceased or diminished. So we have a full appreciation that an employer can make an employee redundant. However, redundancy, again, is not something that can be done just arbitrarily. There is a process that must be employed by the employer in the context of redundancy. Now, here's a slight humor bit. And I'll tell you that the redundancy process is not this, okay? Where this person is saying, listen, or my mother said to me, pick one and you're not it, and so therefore I'm letting you go. That's not redundancy. So we now have the process that the employer must follow if there is going to be redundancy. And again, it speaks to where there are 20 employees to be dismissed. The process is this: not less than 2 weeks. And so we now understand if something would have occurred, let's say around the 15th of March, in our calculation, the 1st of June would be the date in which the consultation in writing is forwarded to the minister, where there are 20 or more employees. So the first date that you, the employee, is looking at now, and the employer, is the 1st of June, meaning to say that the employer is now writing to the minister and saying, in respect to my business A, I'm going to have to make 20 or more employees redundant. And so that 1st of June is the letter that goes to the minister. Then it tells us the second step: not later than 1 week. So we now know the 8th of June, prior to dismissal, informing the recognized trade union or the employee's representative of the reason for the dismissals contemplated and the facts, the number and category of persons to be affected, and the period over which the dismissal shall be done. And so these are very, very important considerations that both the employer and the employee will be able to have consideration of. And so after the notification has gone to the minister, after the notification has gone to the recognized trade union or the employee representatives, then you now have to notify the employees after those consultations. That is, consultation with the minister, consultation with the employee representatives, or the recognized trade union. And so this is the process that you want to recognize, that no doubt employers and employees are now applying their minds to say whether in fact this is going to happen. And so these are the dates you want to be taking very serious consideration of. It tells us now again, in terms of redundancy, where there are less than 20 employees, these are the dates again. And I'm just using these dates in terms of having regard to whether persons were laid off or about between, say, the 15th of March, 16th, 17th, 18th, that period. So the 8th of June, again now, less than 20 employees, there's going to be consultation in writing with the minister. That's the first step. And on that very same date, it says not later than 1 week, again the 8th of June, prior to dismissal, inform the recognized trade union or the employee representatives of, again, the reason for the dismissal, the number and category of persons to be affected, the period over which the dismissal shall be done. And so we have a very clear articulation under the Act that if, again, there's going to be any sort of redundancy because the business is not coming back on stream, that particular function is not coming back on stream, there's a very specific process that must be employed by the employer as it relates to redundancy. Now, before I go to the redundancy pay, I want to highlight a recent ruling from Justice Charles on the issue of the Employment Act of 2017. And she says that this is a mandatory obligation for the employer to follow as it relates to making employees redundant. And this is very important. So it's not something that the employer can escape. It is a mandatory obligation that they must follow when they now have regards to seeking to make persons redundant. So let's say, for example, if unfortunately you find yourself in that category of people, category of employees, that may be made redundant, your question is, how much am I entitled to? And the Act tells us very clearly, if the individual, if the employee is employed 12 months or more, and when I say 12 months or more, I'm highlighting this part right here. This is relating to line staff members. So where there's a line staff member, it tells us that 2 weeks notice or 2 weeks basic pay in lieu of notice, and 2 weeks basic pay for each year of employment up to 24. And so we have a very clear appreciation as to what it is that you are entitled to if you're a line staff member. Then it says the person saw in a supervisory position, it tells us again, your entitlement is 1 month's notice or 1 month's basic pay in lieu of notice, and 1 month's basic pay or prorated for each year of employment up to 48 weeks. So this is your entitlement as relates to the redundancy pay. And so if you're called in, at least you have an appreciation as to what the redundancy pay is and what you're entitled to. The other points I wish for you to give consideration to in this whole consideration of redundancy, and here, these are as follows. Employees may be redundant to be given priority for any new employment within 12 months from the date of the dismissal. What does that mean? So it means that, for example, if an employee is let go, let's say on the 15th of June, God forbid, 2020, the Act says that for a 1 year period, that particular employee ought to be given priority if the employer now, for good reasons, has an uptick in business and now need to bring on employees. So it is saying to us that if there's now an uptick in business, then priority ought to be given to the employee made redundant within a 12-month period from the date of the dismissal. So that's the first consideration. The second consideration is this: the redundancy pay be given on or before the dismissal itself. I pause here because this is having regard to the entitlement of the employee. And so if you call the employee in sometime in June and you say to the individual, I'm going to let you go, at the time that you let the employee go, you have a mandatory obligation to pay that particular employee his or her redundancy pay at that particular point. And I say that because I think a great number of companies going through the COVID-19 pandemic are finding themselves cash strapped. And quite frankly, I do believe that there may be some companies who are going to find themselves in a position where after the 12-week period, they are not going to be opening. They're going to have to lay employees off, but more importantly, they're not going to have the money to pay the redundancy pay that is due to the employees at that time. And so even though the Act says very specifically it ought to be given, then the employees are going to be saying, okay, I want my money, and the employer is saying, yes, I know, I owe you the money, but the truth is I don't have it. And so it's really going to be a concern at that particular point for the employee to say, okay, what am I going to do in this particular situation? The Employment Act again tells us that in terms of this particular situation, this is a claim that has a right before the tribunal, which can be put there. And it also tells us very specifically, if you look at this here, let's go back to it. Redundancy pay is a preferred debt in bankruptcy or liquidation. So let's say, for example, the employer says to the employee, I don't have the money. The employee says, okay, well, if you don't have the money, I've got to do what I've got to do. And so therefore, they no doubt, let's say if the claim is $1,000 or more, they then maybe, and I say maybe because liquidation and bankruptcy claims are a kettle of fish on its own, but I'm saying if they were to seek to try to get a judgment, they can get the judgment. They get a judgment before the industrial tribunal, and then the judgment itself from the industrial tribunal now has to be enforced by the Supreme Court. And so you've now gone through an entire process from the tribunal to the Supreme Court. And so the employee is saying, at what point am I able to get my redundancy pay where my employer did not pay it to me? And I have this judgment from the industrial tribunal, which I'm seeking now to enforce via the Supreme Court. But you've come to find out that the reality is this particular business maybe, let's say for example, it's a trading as company, doesn't have any assets. The employer doesn't have any assets. And so though you have a judgment in your hand, the ability to enforce that judgment may seem somewhat difficult on the basis that there are no assets to be seized having regard to your judgment. So this is going to be a very serious concern for, I hope not, but maybe for some employees where they now understand that there is something I have in my hand that I have the ability to redeem, but there's nothing against which I can redeem my redundancy pay. So the next few weeks are going to be very interesting and challenging times when we start to now give consideration to what companies come back online. At what level do they come back online? If redundancies do come into effect, what ability do they have to pay? There is now the cry, we don't have any money because of the pandemic, COVID-19. So these are going to be very, very serious concerns.
Now, Darren, I just want to point out to you, you have about 10 more minutes left.
Okay.
So I just wanted to keep you honest.
Okay, thank you. Okay, I want to make one quick point. I'll move on very quickly. This particular provision here, the deemed redundancy, I'm talking now where the employee about the 15th of March, 16th of March was laid off, coming up now to the 12-week period, does not, ladies and gentlemen, does not apply to employees in the hospitality industry or any other industry designated by the minister as a seasonal industry. And so therefore, the 12-week period I was speaking of earlier does not apply to the hotel industry because they have their own industrial agreements and other provisions that govern at what level the employer may be able to lay off, etc. So if we spoke about the 12-week period, anybody employed in the hotel industry, that particular provision does not apply to you. Okay, I spoke about redundancy, but there's also an important part in the Employment Act, the substantive legislation, where it speaks of the issue of unfair dismissal. And the reason I'm invoking the consideration of unfair dismissal is because a number of employees are going to be concerned about how is that selection process to make someone redundant. And if it appears to be, well, I picked this particular person that I never did like them, or this appears to be COVID-19 has provided a reason for me to terminate this employee, I just get rid of them. But I'm a bartender and there are two of us on the bar is open, but you've only chosen me and you've left John. The question in the employee's mind is going to be, was that selection process fair? And the Employment Act says that if these things here, let's go back to it, please, are not fair, then for the purpose of the act, the dismissal shall be regarded as unfair. And so we have to be mindful of what the Employment Act says in respect to dismissal on the grounds of redundancy and how that process ought to be. Okay, let's move on very quickly. Again, working remotely is now the new workplace. And some of us, I find yourselves in your pajamas all day long, but let's now look at the new workplace and what it means. And I brought up this particular piece here before we get into the issues. It's because when we now start talking about the new workplace means that there are some changes that are going to come. Let's say, for example, you're working remotely. It's now mandatory to wear face masks. There are glass dividers between clients and employees, social distancing, et cetera, et cetera. So there are changes in the workplace. There may be the temptation by some employees or employers, but more specifically employees, to resist these changes on the basis of saying, prior to COVID-19, we never used to do these things. These things did not form a part of my contract. And so therefore, I'm not going to comply with what these things are that you're seeking to impose upon me. I would say to employees, be very careful and be mindful of this here. When you're now saying, listen, because you're imposing these things on me, you are now making a unilateral variation, meaning of your own employer, making a variation of my contract. And for you to consider there to be a unilateral variation, here's what the court says you must have consideration of. The conduct of the employer, let's put the employer there, must be a significant breach going to the root of the contract of the employment, or which shows that the employer no longer intends to be bound by one or more of the essential terms. So employee, the first consideration you're going to have to apply your mind to is whether or not the change being proposed is a significant breach going to the root of the contract, and that the employer is demonstrating to you, he or she, it no longer intends to be bound by the term. And I would say this to you, that let's say, for example, the imposition of the wearing of face masks and you resisting it is not something that you can say is a significant breach going to the root of the contract. And here's why I say that. The Health and Safety Act, at Work Act, is an act that tells the employer and the employee what he or she, it can and cannot do, having regard to the health and safety of employees. See, here's what it says. It shall be the duty of every employer to ensure, so far as reasonably practicable, the health and safety and welfare of all of his employees. So where the employer says to the employee, you must now wear face masks, they are having regard to the fact that they have an obligation, a statutory obligation, to make certain that they're protecting the health and safety of all of the employees. They're not exposed to risks, etc. So that's the first point I would say to employees. Be very careful of when you make the argument that the employer is doing something that varies my contract. You must ask yourself, does it go to the root of the contract? And here's the other point I would say as well, when we now talk about the new workplace. There is going to be a difference in terms of practices that you would find from workplace A to workplace B. For example, a large food store chain may have the resources to put up a plexiglass that divides the cashier from the customer. That's a large food store chain. However, the mom and pop store around the corner, again having employees, do not have the resources to go ahead and put up that plexiglass between the employee and the customer. So the employee now says, hold on, I went into food store A and I saw this practice, and I think it's a very good one. And I think my employer being the mom and pop store, must now also employ that very same practice. If that is said, again, you come back to this word, reasonably practicable, reasonably being a subjective word. And so therefore, if the employer, being the mom and pop store, don't have the very same resources that the large food store chain has, I think it's going to be a very difficult argument for the employee to say that because you do not have up the plexiglass, that then says that you're now in violation of the Health and Safety Work Act, I'm not coming to work. Once the employer can demonstrate that he or she, it has taken all reasonable steps, so therefore they may not have up the plexiglass, but they're providing you with masks, they're providing you with hand sanitizers, et cetera, to the extent that their resources permit. It is only my argument that that particular employer has discharged the burden imposed under the Health and Safety at Work Act in terms of taking reasonable steps to ensure the health and safety. Okay?
Five more minutes, Darren.
Okay. Now, here's an important point. The employer, however, cannot charge the employee for those steps that he or she is taking to ensure the health and safety of the employees. So they may provide you with masks. Now, if they provide you with mask aid, which is let's use this word, is a medically recognized mask, but you now, the employee says, I don't want that particular mask, I want something else. And if you want something else in that particular situation, you're going to have to pay for that something else. But as long as the employer has discharged their burden by providing you with, let's say, the medically recognized masks, then they've discharged their burden. But they can't charge you at first instance, let's use that word, at first instance, where they provided you with the equipment to make sure of your health and safety. Let me just skip through this. Of course, there is the obligation of the employee as well to take reasonable care for the health and safety of himself and other persons who may be affected by his acts or omissions. And again, acts or omissions carrying the same weight. So if you omit to wear your mask at work and you expose other employees and or customers to the pandemic, where you are asymptomatic carrier, then you, the employee, have not satisfied the requirements under the Act. So there's an obligation on both the employer and the employee. So we've looked quickly at what some of the issues are. Can employees be required to wear face masks? And my answer is yes. And the reasoning for it is, again, the obligation under the Health and Safety Act. How to do it? Direct communication. Again, we have the situation of employees of working in close proximity to each other. What can we do? And again, these are some very practical considerations as to what you can and cannot do, where you're talking in terms of how you go ahead and make the adjustments. And this will come perhaps in terms of close proximity, persons who are standing at desks, who are standing at loading docks, or let's say, for example, using the same phone, maybe in a workplace. Of course, it's going to be a concern. Am I now required to use that phone because I'm concerned that I don't know who has it? How can I be in a location where all of us are using the same phone? And then it goes back to the question, what did the employer do to mitigate those risks? Do they have a hand sanitizer? Do they have Lysol or anything at the phone booth, etc.? So those are going to be very serious concerns for employees. Again, the question may be, I can't come to work because I'm now homeschooling. I've got to take care of my children. Must they be paid? And the answer is, it depends. The employer is looking, for example, at very practical concerns, practical considerations. If the employee has unused vacation or other paid leave per his or her contract, then you may have regard to the vacation time that it may be there. So you're going to have to work through those issues. I don't think time, Wellington, will permit us to go into the issue of force majeure.
I trust your judgment call.
Because you say they pretty much follow the time in respect to the presentation.
Yeah, I mean, we have, if we end now, we can get about 35 minutes of questions in.
Okay.
How much longer would force majeure take?
Not very long.
Let's do it. Let's
Okay,
do it.
let's just go through this concept. So we've looked at employment issues. I'm just going to switch over just very quickly, to a legal concept that has been floating in the air in the mind of a lot of people since COVID-19. And it's this question of, I have this contract, COVID-19 has come in, and really and truly, I don't think I ought to, or I have an obligation to perform that contract anymore. And so there is in the mind of that particular individual a way to bring that contract to an end. And some persons may have even specifically used the word as saying, you know what, my contract has been frustrated. So force majeure and frustration have been really two keywords floating about in the context of contracts. We look at them very quickly. Force majeure is a contractual term by which one or both of the parties is excused from performance of the contract in whole or in part, or is entitled to suspend performance or to claim an extension of time for performance upon the happening of a specified event. I have to pause there. The key point to be taken away from this definition of force majeure is it's a contractual term here, and it's upon the happening of a specified event. So it means simply this, that in the contract, they've specifically outlined a force majeure term, and they have detailed very specifically what are the events that can cause the force majeure to be triggered. So that's a very important understanding to have. So when you start to say, okay, can I escape this contract on the premise of force majeure, the first thing you have to do is to literally go back to your contract and have a look at it. Do you have in your contract a specified force majeure term? And if you do not have a specified force majeure term, you cannot rely on the concept of force majeure. What may, and I use the word may very carefully, what may be available to you is this concept of frustration. And frustration is this. Frustration of a contract occurs when there supervenes an event without default of either party and for which contract is made, which knows, and what it talks about is this. Let's paraphrase it. So there's an event that occurs that now radically changes the nature of the contract. Let's do it again. It radically changes the nature of the contract. The nature of the contract, ladies and gentlemen, is not changed simply on the basis that it becomes much more expensive or much more onerous to perform. So if your only gripe is, it is now much more expensive, then I'm afraid that the concept of frustration will not help you. Frustration, again, has very strict requirements under the law that consideration must be given to. And so whether COVID-19 is going to be considered an event of frustration is really now we're looking at those decisions to see if it does, because we'd have to look specifically at what it is. Again, you're saying that my contract is, that's the first point. We're looking at two, what is it that you're required to do? And more specifically, how is it you say now that this particular COVID-19 pandemic has caused you not to be able to perform that contract, or you're saying that it has significantly changed the nature of your performance? I think a great number of persons are going to find themselves really in regards to the major issues going to be, in truth, it is now much more expensive for me to do it. And I'm saying to you, ladies and gentlemen, if in fact that is the case, I'm afraid at this point, frustration will not be a concept available to you. I think it's a good way for us to pause and to now invite questions. But as we go through this again, I say to all of you, what lies behind us? COVID-19. What lies ahead of us? Maybe COVID-19. Are really small matters compared to what lies within us. And so therefore, we have the ability to get through this together, and by God's grace we will.
Absolutely. Thank you, Darren, for a very well put together presentation. It is now 1:54. I'd like for us to slightly adjust our time, and I would ask for your patience in this regard. So we will start with questions now, and we'll take those questions from now until about 2:25. And then at 2:25, we'll wrap up, and by 2:35, we will be done. So if we're 5 or 6 minutes over, I do ask for your patience in that regard. If someone has to drop off right at 2:30, that's understood. But if you can give us a few minutes over, we would appreciate it, because we'd like to really get into your questions, okay? Now, before I hand it over to Kishel to take us through the Q&A session, I do want for Peter Gowdy to give us a very quick update relative to his participation on the National Tripartite Council, the Chamber, and also the Hotels Association. So Peter, over to you.
Yeah, I just wanted to mention to people that there has been recommendations, and I can only tell you that, recommendations. I don't guarantee anything. Don't ever get me out of context. And I've already been in the paper on this. Both all of the National Tripartite Council, the Bahamas Hotel Employers Association, I got to get all that right, and of course the Bahamas Chamber of Commerce and Employers Confederation are well aware that the whole country doesn't want to make a workforce redundant. And so, not unlike what happened with Hurricane Dorian, we have asked the government to give serious consideration to extending the unemployment benefit and effectively, if you want, I don't know if I'm using the right legal word, but to amend the Employment Act so that people aren't made redundant. It's one of those things where it makes no sense to make everybody redundant when there are no jobs. So suddenly you put a whole bunch of people out of work, and in the case of hotels, we're talking tens of thousands, and they can't find jobs. So we'll have to wait and see. We're going to have the Prime Minister at 5 o'clock tonight, as we all know. If you didn't know, the Prime Minister is on at 5 o'clock tonight. And I'm very curious as to see what's going to go on. And I think, if I can add to this, I'm sorry to do this, Wellington, but I just thought I'd clarify everything I'm thinking.
Sure.
If the country, except for Bimini, if the country can get rid of COVID-19 without anybody coming within our borders, then our domestic economy can expand, because we're going to be in good shape. So that may take care of a lot of our redundancies, but it won't, or unemployment, but it won't in the hotel industries, except for some type of local tourism.
Yeah.
So anyways, those are the recommendations that have been made. I know Darren wouldn't have been in a position to say that, and I don't want people to get too frightened, but I think we all should be ready for June the 15th or whatever the magic day is for the company. But we have made those recommendations, and we're waiting to hear. So I thought I would interject that. I know that's why you put me up, just so that everybody is aware of it, so those questions wouldn't come up when nobody has an answer. Okay, so that's my 5 cents worth for your seminar today, and I appreciate it, because I do appreciate these.
Thank you, Peter.
You're welcome.
Much appreciated, my friend. So Kishel, over to you. You know, we got a couple questions before the webinar, and we have several in the chat. I'll leave it up to you to decide how you want to go through those. And you're talking on mute.
Oh, the famous mute. Hello, everyone. And so my role now is to field the many questions that have come through. We've had questions before. We also have several questions in the chat. I am going to start with those who emailed their question in advance, and then go kind of as they come in. and I will be fielding the questions as they continue to come in. So I want to start with, and some of these you may have touched on, Darren, so I may bring one or two questions that will help to clarify some of the things that you touched on, given people's specific situations. And so one of the questions were in regards to the company taking a percentage out of a staff's salary because of COVID-19. Does the employer have to pay that percentage back, or don't they have to, right? So we've had companies who saying, I'm going to cut your salary, I'm going to take a percentage out. Do they have to pay that back, or don't they have to? And that's the first question.
I think in order to answer that question, I would need to get more specifics as to why it was taken out. Let's say, for example, are you saying that your wages was just cut, meaning to say that you did or did not work, or was it just they took it out? To answer that question, I would need to know why the wages were taken out. What was the basis for taking it out? Remember I said,
go on.
Remember I said that I'm not sure if the salary was taken out on the premise of we now have to go ahead, let's say, for example, and upgrade our shop to make the shop a better working place for you, the employee. Mm-hmm. If it is that was the particular reason for taking portions of the employee's salary, no, they cannot do that.
Okay. What about a situation where, so I have certain clients who they are cutting their time that the employee works because of course there's not enough work. Also, there's not enough revenue coming in. And so in order to ensure that the employee still have a salary, they're cutting their time, i.e. their pay. Speak to that.
Yeah, so basically, if you're talking in terms, let's say, for example, this is a standard hourly employee who is supposed to work 40 hours a week. They're now working less than 40 hours a week. They're getting paid for what time they work.
Okay.
So yeah, that's a straightforward consideration. You're paid for the hours of work.
Okay, got it. So let's go on to, because I'll tell you now that we're going to go through as many questions as the time permits, but I'm pretty sure we may not get to them all.
Yeah. So actually, so Keisha, sorry to interrupt you. Mm-hmm. So with that in mind, Darren, would you I think someone.
Yeah, could just mute. Yeah, mute.
Yeah, let me mute them. But Darren, would you permit us, if we don't get all of our questions answered, to send those to you and get some written responses?
Sure, absolutely.
Okay, all right, thank you.
Perfect. So this is a specific situation. I know you spoke to the difference in the hospitality industry, but I thought this was still something to speak to, because I know that we have a lot of persons, just by names, who may be in a similar situation. So my husband works at a hotel in non-management. At the end of 12 weeks, what should he expect to happen in regards to his employer? Should he expect a letter of termination to advise termination, or is it to be automatic that he will no longer be employed there? Okay.
So again, we spoke to the fact that persons employed in the employment industry, the provision that we referred to in talks in terms of the 12-week period does not apply. So I'll give you a hypothetical situation, okay? If the employee employed at a hotel was laid off, March thereabout, and goes back to work now, let's say on the 15th of June. If the employer is then saying to that particular employee, I've got no more work for you, or the business itself is shutting down, let's say, for example, a restaurant, okay, is shutting down, then at that particular point, the employer is saying to the employee, I'm making you redundant. Mm-hmm. If the employee is now being made redundant, then the provision applies now in terms of what amount of pay that particular employee ought to get. And with this particular person being a line staff member, you now have 2 weeks notice or 2 weeks pay in lieu of notice, and then 2 weeks for each year, up to 24 weeks. So that's the first consideration. There may be redundancy. Or, again, specific to the hotel industry, the employer may say to the employee, where you are now working 5 days, you're now working 3, you're now working 4, you're now making 2. Or there may be a further consideration where they're saying, okay, fine, you were employed as a lifeguard out on the pool deck. We're no longer opening the pool deck at this particular moment. However, we can bring you on the inside to, let's say, for example, act as a houseman inside the hotel. And so now the employer is giving consideration to now alternative employment. And so those may be the scenarios this particular employee may be faced with. A, redundancy. If it is being redundancy, then fine. They know what their entitlement is. 2 weeks notice, 2 weeks pay in lieu of notice, 2 weeks for each year, up to 24. If it's not going to be redundancy, it may be now a reduced work week, reduced work hours, or it may be a transfer to a different department.
Okay, okay, thanks for making that clear. So I think you would have answered this in your presentation, but here is another specific thing, and I think it's so relevant because I've heard a similar situation. So is it legal for a company to say to you or an employee that they can either sign this letter now agreeing to be rehired with lowest tenure and benefits such as vacation, current salary, or don't sign this and be terminated in order to collect a check?
I think
interesting question.
Right, and the short answer is no.
Yeah.
Yeah, in the presentation, they would have spoken about what layoffs mean. It doesn't mean that your employment stops. So you cannot have the employee under duress and say to him or her, okay, we're laying you off for 12 weeks or whatever period of time. You must now sign this in order for you to get some pay. No, can't do it.
Yeah. Yeah, very, very clear. And just another one, just to be clear, when I get a letter as an employee, the reason for the letter should be redundancy. This is the question that comes in.
If it is that they're making you redundant. And so if they're making you redundant, then you know that there's a particular process that has to be employed in respect to the redundancy. If they're bear in mind, an employer can terminate you at any time. If they do, and if the reason is not redundancy, then they have an obligation to pay your notice and says they have an obligation to pay your notice pay. And again, the notice pay again is for line staff members, 2 weeks notice or 2 weeks pay in lieu of notice, 2 weeks for each year, up to 24, management, 1 month, up to 48. So if they want to let you go, they have to pay you pursuant to the act.
Yeah, okay. And so this question came in, it says, if you say that layoffs do not interrupt employment, are employees expected to make NIB payments during the layoff period?
Yeah, I mean, NIB contribution is a statutory obligation. So I didn't see any pronouncement from, and I say pronouncement, I'm talking in terms of any of the emergency orders signed by the Governor General that said that the requirement or the suspension of NIB has come into effect.
Okay.
And I mean, quite frankly, NIB needs all the money it can get right now.
Yeah.
Boy, Darren, you read my mind.
You know?
Well, that's an interesting one because again, the employer has no money yeah, but they're still obligated to pay. So that's another one of those interesting dynamics as time go on that we probably need to be
catch 22.
Yeah. Okay, so let me go on. If an employer is upgrading the services, let's see. Okay, I need to come back to that question. There was a lot there. So there are conditions in order to, what are the conditions in order to receive the entitlements in the 2017 Employment Act, i.e., do they have to be employed for a particular minimum period?
In terms of the redundancy pay? Yeah, 1 year. 12
1
months
year.
or more.
Okay, good. I love that question. And someone also asked if there was a recording of this. Yes, there will be a recording of this and it will be sent out.
Yes.
Okay. Another question, in an environment where excess vacation balances exist, can you give some guidance on how an employer can go about having those employees liquidate some of those balances during this time? Of course, there are some variables, but can you speak to that?
If, let's say, for example, the first thing that I would be guided by is A, the contract of employment, and B, the actual, let's say, the example, employee handbook. Some organizations are very specific in terms of excess vacation. So let's say, for example, we're now in May, going into June, and you go back to work, let's say, for example, June, July, but you've got another 4 to 6 weeks vacation, but the contract of employment, the employee handbook says that you cannot carry over your vacation time into 2021. I think the consideration is going to really be that the employer will really want for the employees to use up their vacation time, because where it's not possible to carry it over and they can't just not pay, I think you're going to find a great number of employees are saying, you're using your vacation in certain circumstances assists us because we now have got to have the social distancing. And so therefore, when you're on vacation, that really minimizes the bodies in the organization, and it allows us to go ahead to be able to have this reduced staff, which is now allowing for the social distancing. So I think for a great number of employees, you're not probably going to find any difficulty with them saying, use your vacation.
Yeah. We have a follow-up, and I know that's a lot of variables, but I want to touch back on it because I think it's one of those interesting points regarding the NIB comment. But NIB is only on wages earned, and if there are no earnings, should there be no NIB payments? So that's at least with two questions coming based on that.
Yeah, no,
yeah, and I sorry, Darren, to interrupt. And I just want to chime in. I know that Peter also wrote me a note privately where he wanted to chime in on this. So Peter, feel free after Darren provides his commentary.
Yeah. We're speaking in regards to where there's monies earned. I mean, if you're not working, what you paying the NIB on?
Okay.
There's nothing to pay it on. But we're talking in terms of when does the obligation, in terms of the statutory obligation, arises to pay NIB? That obligation arises when you get paid. If there's no pay, you can't say that I've got something to pay the NIB from. So yes, it's based on what you've earned. Yeah.
Got it. Okay.
Yeah, my only comment to that, Darren, is that's not the way it came across.
Okay.
That if that somebody who is laid off and not getting paid a nickel, except even in a lot of cases, still to this day, people have still not received their unemployment insurance benefits.
Mm-hmm.
I don't know how people are surviving out there, seriously. But anyway, I know, God bless them. But if you're not earning anything from the company, they can't pay NIB. They don't have a payroll.
Okay, yeah, that's clarifying that. That was good. I love that.
Sure. No, I'm more than happy to clarify. Yes, it's based on what you earned. Yeah.
Yeah, perfect. So let's continue. And the questions are coming in, Darren. So in a work from home setting, we know almost everyone is working from home.
Right.
What obligation, if any, does the employer have in helping the employee set up an office, quote unquote, in relation to internet costs, telephone costs, maybe laptops? Are there any obligations there on the employer side?
Right. That's a very interesting one. I think the employer will go to the extent that they reasonably can afford. And let me say this very carefully. So you, the employee, already have, I think they have an obligation, let's say, for example, to provide you with a laptop if you're asking for me to be online. So you're provided with a laptop. you, the employee, now already have internet access. And so you're saying to yourself, okay, my employer now is saying to me that I've got to put in 8 hours of work per day. So that's 8 hours of my internet time that I'm paying for, that I'm using for you. To be honest with you, I think there's going to have to be some conversation, some trade-off between the employer and the employee to say, okay, what amount of your cost is directly attributable to the work that I am providing for you, the employer? And if we are able to strike some balance as to how you get compensation. Now, compensation may not be physically in money. It may be some time or something of that sort. And so I think there's no strict guideline that we can follow to say that if I work from home, you have an obligation to pay my internet provider for the time that I'm on. I think what the obligation of the employee is at minimum to provide you with the equipment, and on the face of it, that first equipment is either the desktop or the laptop that you're going to be using. And if, let's say, for example, if you do not have internet at home at all, then again, that's now going to shift to the employer to say, okay, fine. In order for me to work remotely, I'm going to need that access to the internet that you're going to have to provide. So you're going to have to provide the equipment. The consideration is really going to be the cost attributed towards the equipment, specifically where the employee has the internet access at home and they're saying, you're asking for me to use my internet access. How am I going to be compensated for that?
Right. Yeah, that's another interesting one. Wow. Wow. Okay, so let me go on. And so there are a couple of questions that came in similar to this. And so I think you would have touched on it in your presentation, but it's come up in several different forms again. So if an employee is given alternative work or alternate work, what considerations can be made regarding rate of pay, right? Will they get the new rate of pay for the job that they will perform, or will they have to remain at the same rate of pay as their former job? Yeah.
Okay, I want to say this. In this context of COVID-19 and the reduction of work, there's really going to have to be a great level of conversation between the employee and the employer, where the employee is now going to a different work function. And let's say, for example, that work function is a lateral move. That's the first consideration in terms of the rate of pay. Then you have to give consideration, okay, fine. It is not a lateral move. There is perhaps now a more burdensome task put on the employee in respect to that particular function, this new function now that they're taking on. That's the second consideration. However, the employer says, John, I know I'm giving you more work, but the truth of the matter is I have to give you more work because I can't employ a third person to do the work. However, we can make a notation in terms of what your rate of pay is and have an agreement that in the future, Lord willing, that I'm able now to compensate you for if business were to pick up because I'm now making a slight adjustment here. I think that's going to have to be because the employer is saying, I do not have the money to pay you now at the rate of pay at which that particular job description has assigned to it. The employee is going to have to say to him or herself whether in fact, okay, having regard to what the employer is saying to me in terms of acknowledging one, there is supposed to be a change in the rate of pay, but the employer has demonstrated very honestly to me that there is no money to pay that increase, whether I'm prepared to accept that the difference between what I'm going to earn and what I should earn can be paid at a later date, and or if there is some other form of pay that I can get let's say in terms of benefits or time off, that kind of thing. So I think that conversation has got to be exchanged between the employer and the employee.
Yeah, and I love that because, I mean, as I'm filtering questions, a lot of questions are similar to what you are talking about. And one thing that I'm hearing is it really boils down to communication and compromise.
Sure.
Yes.
Between the employer and the employee, because it's there. You can almost guarantee, probably not in every job and every industry, but you can always guarantee that there are going to be some adjustments or changes to how someone works, considering what's going on. And so that's what I'm hearing. And just to be clear, this is not necessarily, because one of the questions that's kind of tied to it is the employer is not necessarily violating the law in making these changes. They're making adjustments as their work situation changes, and it comes back to how am I going to communicate that to my employee, and how can we come to some compromise is what I'm hearing.
Right. So the point is this, again, as we go through this process, let's say, for example, you have an employee who has now got to go into a different job function that attracts a different rate of pay.
Yeah.
And the employee says to the employer, I want that particular new increase in rate of pay, and if I don't get it, I'm not going to perform the function. I think we're going to really have to apply our mind and say, okay, fine, if you say there's been a unilateral variation of my contract, and you may be dead right, I'm not saying that you will not, you may be dead right to say that my contract has been unilaterally varied. You've got to apply a very practical consideration to, okay, I'm now going to sue my employer for this unilateral variation of my contract. Okay, good. To the scenario I brought in the beginning. You can very well sue your employer and you can very well get a judgment. The question is, does the employer have anything against which you can enforce that judgment? And so before you run off to the court to enforce a right that may exist, you're asking yourself the very practical question. What sort of conversation can the employer and the employee have to bring a compromise to the situation, whereas I'm able to maintain my employment, they're able to maintain the business to employ me?
Yeah, it's almost a win-win.
Right.
You've got to have, in this environment, I believe that there are going to be some employees and employees who will take advantage of it. Let me just say that. There will be some who will do it.
Yes, yeah.
But I think for the most part, though, we're going to have to, conversation is going to have to be the key in terms of trying to understand how we navigate through these positions, how we navigate through the situation in order for, at the end of the day, I'm able to maintain my employment, they're able to maintain their business to employ me.
Yes. Now, I just want to put an insert in there. So I've been keeping a Word document where I'm copying all of the questions so that you can provide a response, Darren. We're upwards to about 40 questions that I've received through chat, through WhatsApp, and through email. So what I'd like to do is we can go straight until 2:30 answering questions, and then we'll wrap up between 2:30 and 2:40. I know some individuals may have joined after I would have said this. This session is being recorded, so you can gain access to it on our WHI YouTube channel. We will also capture every single question, and Darren has been gracious enough to provide written responses to us, which will be sent out to the mailing list and everyone who participates. But we understand your time is important, so if you need to leave at 2:30, please avail yourself of that, and we'll communicate with you further. Over to you, Keisha.
Okay, thank you for that. Boy, hot topic, man. Okay.
Hot topic.
And one of the things that I want, and it's going back to that point, because again, similar questions, just make it clear that if an employee doesn't agree with what the employer is saying or offering, and they choose to go the legal route, and an employer doesn't have the revenue, kind of speak to that again, because again, that's coming up a lot in the questions indirectly. What if I know I have a right I'm going to exercise my right to sue, but the employer is saying, I don't have any money. I want you to speak to that, because, so to give that clarity around what could be the end result if an employee decides to go that route.
Okay, so in terms of the litigation process, the employee says, I have a right. So they started their process either by going to the Department of Labor, which then takes the matter from the Department of Labor to the Industrial Tribunal. And at the Industrial Tribunal, you get a judgment which says that employer A owes employee B $2,000. Once the employee gets that judgment, then they now have to take the ruling from the Industrial Tribunal and now have it enforced by the Supreme Court. And the reason being is because the Industrial Tribunal rulings cannot be enforced in and of themselves. So you now, the employee, you've incurred your costs, perhaps legal fees, to have the matter go from the Department of Labor to the Industrial Tribunal, and now you're taking on a Supreme Court action. So you take the Supreme Court action, and again, the Supreme Court gives you judgment where it says